Okay, Google. Are you listening?
They're listening, and when they hear that wake-up word, they begin to respond to your command.
When you say, Alexa, play some jazz, they know exactly what to do. But that means they're listening all the time. All the time.
They have an artificial intelligence built in that actually takes the recording of what you say, uploads it to the cloud where it's processed by the servers of Google or whatever company is operating the assistant.
The concerns are, where is that information being stored? How long is it being stored for? Who is looking at it besides the manufacturer of the device?
Many of us have nothing illegal to hide, because we're not, but we all have private spaces.
Okay, Google. What is privacy?
You don't find the word privacy in the Constitution anywhere. So our privacy rights, such as they are, arise from an interpretation of the Constitution rather than directly from a line of text in the Constitution.
Going back to a case called Katz, we've developed this idea of a reasonable expectation of privacy.
And in Katz, the Supreme Court found that you had to get a warrant to wiretap a phone booth, and that was because they read the Fourth Amendment to apply to the person rather than the physical location.
Well, the Fourth Amendment, of course, protects us from unreasonable searches and seizures of, among other things, our papers and effects.
So that was a very novel reading of the Fourth Amendment for that time. And since then, it's become second nature to us.
Both courts and Congress, through creating statutory protections, have recognized that the Constitution and sound policy mean that there should be limits on the government's ability to access electronic information that we transmit and that is held about us by third-party providers.
Back in the 1970s, the courts developed something called the third-party doctrine.
So the third-party doctrine is a principle of Fourth Amendment law that says that when you divulge information to a third party, that your reasonable expectation of privacy in that information has been extinguished, at least in many cases.
That's the idea that if I give you information voluntarily, I cannot protect it by making you not give it to the government.
Is it really voluntary? What's the other option? You know, if you don't have email, what's the option? No email, right? Good luck getting a job.
There's also an ongoing push to enact legislation that actually expands the existing statutory protection that would make it clear that a warrant is required in almost all circumstances when the government wants to compel a third party to hand over your information.
So for instance, already Congress protects financial information, your credit card information or what you bought from Amazon through your Google or Amazon Echo device. The financial transaction information has a higher level of protection under statute than other information. Healthcare is another example. But your non-content communication, when you ordered something, what phone number you dialed, those are kind of neutral pieces of information, but in the aggregate, they paint a very realistic picture of who you are, where you like to go, what you search for, and what matters to you.
Okay, Google. Who am I?
If I know that you go to the gym, I know something about your body image and yourself. If I know that you go to the AA meeting every Wednesday, I know something about your past. I know if you go to your psychiatrist, if you go to church. Each of these things tells us something about you.
The New York Times says an irate father asked a Target manager why his teenage daughter was receiving baby coupons in the mail. Turns out his daughter was pregnant and had told no one at all, but she had been shopping at Target for products that an expectant mom typically buys.
Companies get permission to collect our information by virtue of the fact that we enter into commercial relationships with them. It may not occur in the way that we normally think about it, where you walk into a store or where you sit down and sign a document, but when you install an app on your phone, you probably hit that accept button without actually reading any of the fine print.
This is the infamous terms and conditions that nobody reads.
So when a company says in its privacy policy that it will only collect information and use it in certain ways, that's essentially a contract. When you're inside a store, you assume that the clerk can see where you're walking and will also see what you purchase. And that same expectation, I think, should occur online when we're interacting with a company, that it's going to observe the way in which we use its product.
So the third-party doctrine actually creates a situation where more data is available than would be protected by the Fourth Amendment.
Okay, Google. Should I be concerned?
I do not own a digital home assistant device like Alexa or any of the other ones, and you couldn't pay me to own one. They are essentially home wiretapping devices that are designed to collect every bit of information about you, and that concerns me.
There are solutions to these problems, but they require political will, and they require the voice of consumers to kind of fight for them.
I think technology will solve the problems that arise and allow consumers to achieve the level of privacy and security that they desire.
That's why it's even more critical for law students today to be involved in these issues, because they have personal experience with an Amazon Echo or a Google Home.
And the only thing that stands between them using the information for good and them using the information for intrusive purposes is law and regulation. The technology is neutral. The impact of it on you is shaped by our law and policy.
Okay, Google. What is the Federalist Society?